Welcome to California in Focus. I'm David Mastio, and today we're talking about Elon Musk, hate speech, and a lawsuit against the state of California. Joining me today is California reporter Kenneth Schrupp. Kenneth, what's going on?
So, big news here out of federal appeals court in the West Coast. The Ninth Circuit Court sided with Elon Musk and X Corporation against a California law that requires companies to report and create definitions for a wide variety of speech violations, such as defining what hate speech or misinformation is. The court said that this law violates the First Amendment by compelling them to have to provide an opinion on very contentious matters by having to define what hate speech or misinformation is.
So it seems to me that X or Facebook or anybody else who is going to comply with this law would have to have like an expert on everything imaginable to help them come to a position about what is hate speech and what is misinformation or disinformation on, an impossibly huge variety of issues. You couldn't do that stuff just off the cuff, right?
No, it'd be very difficult to do. And the author of the bill, AB 587, fairly transparently said that the point of the bill is to increase censorship online. The bill was marketed as a transparency-oriented measure to have social media companies make their content moderation policies and statistics available to the public. The law specifically required companies to create and define the categories of hate speech, racism, extremism, radicalization, disinformation, misinformation, harassment, and foreign political interference. The bill author, Jesse Gabriel, an assembly member from Encino, wrote that the bill will ensure, quote, social media companies moderate or remove hateful or incendiary content on their platforms. He also said that he hopes the bill will, quote, pressure them, end quote, to, quote, eliminate hate speech and disinformation. So in the original lawsuit that X filed in September, the company said the law would, as Jesse Gabriel said, quote, pressure social media companies or eliminate or minimize content that the government has deemed objectionable. It's not just that these companies would have to have experts on hand define these. They would have to define these in mind of what would happen to them if they don't have definitions that are in line with what legislators want to have removed from the public sphere. If they don't comply with what they think legislators want, they could end up with having a lot of their rights revoked or face more regulation from the government.
I can just hear what our friends at the Foundation for Individual Rights and Expression would say about this. I think it's almost a direct quote from their president that hate speech is free speech. The way the First Amendment works is you don't have to defend speech that everybody likes, but the First Amendment is there to protect speech that people don't like. This is like the state government defined all the kinds of speech they don't like and is asking their social media companies to be the police for these items. Is that the way you read it? And what do First Amendment scholars and experts say about this?
Well, I think we can read what the Ninth Circuit, which is famously a little bit more of a left of center judiciary, said about this. They said, quote, insight into whether a social media company considers, for example, a post citing rhetoric from on-campus protests to constitute hate speech, reports about a seized laptop to constitute foreign political interference, or posts about election fraud to constitute misinformation is sensitive, constitutionally protected speech that the state could not otherwise compel a social media company to disclose without satisfying strict scrutiny. What they're saying is by forcing companies to take positions on what is disinformation, what is real, what is not, they're turning these companies into arbiters of what truth is on what are really not fully agreed upon issues where often the truth ends up being the people who were called crazy at the beginning.
Right. That goes to the Hunter Biden laptop. It's really amazing to hear a liberal circuit court cite the Hunter Biden laptop case in a ruling. And in that case, all of the experts said beforehand that this laptop is Russian disinformation. And it turned out the exact opposite was true, that this was just good information that accurately told you what Hunter Biden, the president's son, was up to. And that tells you, in addition to the First Amendment issue that's so hard, it actually seems to require social media companies to have some kind of omniscience that they would know, what the deal was with this laptop on the whole other side of the country. I think that was in Delaware that the laptop was found, a state that X may not even have a presence in.
That's right. It's also worth noting, though, that these laws would apply to all companies that operate in California. So it would have been bullying, the entire world's social media companies to comply with this California law, because this content just has to be seen by Californians. The companies don't even have to be based in California.
Kenneth, thanks for joining us today. Listeners can keep up with this story and more at thecentersquare.com.